So you guys know there's always something going on in the YSL murder trial. Why? Because it is a circus. It is a sideshow. This has been going on for what, 2 years? And it doesn't look like if there's any end in sight.
Young Thug's RICO trial on hold indefinitely after judge's alleged improper meeting. Racketeering trial has been put on hold indefinitely. The winding legal case, ongoing since the rapper's indictment in May 2022, has ground to a halt after Fulton County, Georgia, Judge Glanville was accused of misconduct, according to the New York Times and BBC. On Monday, the judge agreed to send a motion for his recusal from the trial for another judge to weigh in, and that the trial would remain in recess until then, the outlets reported. Thug's defense attorneys have claimed the judge held an improper meeting with prosecutors and a lead witness. Glanville has denied multiple motions for recusal in the last few weeks. Jurors have not heard arguments for 2 weeks, the Times reported.
An affidavit motion to recuse me. You filed an affidavit. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit. 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse ruling. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face.
As you come on to the page, kindly hit the like bell and subscribe to the channel if you haven't done so as yet. And don't forget to put on the notification bell, so you can be notified when I drop the next video. Thank you.
I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right? I'm not contesting where you got the information from, at least not yet.
Yes.
I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So remember, bias. I've got to do something extrajudicial, and I don't, in your particular, something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is. Or what your statement is in terms of your motion to recuse, I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
If I can just finish a minute, I promise. If I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right.
Are you denying at this point?
I'm still denying your motion.
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you were always talking about how the appellate...
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
And are you interested in removing the cloud that's hanging over the case right now, Your Honor?
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you. You have some professional responsibility obligations individually. I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
The certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to deny the motion. Okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
So Judge Glanville asked Attorney Steele if he's got representation. He said yes, and he introduced Ashley Merchant, who walks into the courtroom like the savior, like the big, bad superwoman with the kryptonite. Let's take a listen.
Are you willing to tell me at this point in time who it is that disclosed this information to you?
Well, unbeknownst to me, Glanville was here, but they're not being allowed into your courtroom. I presume they're outside.
So Attorney Steele did not answer in the manner in which Judge Glanville was expecting. He said, I'm paraphrasing, there are attorneys down here on my behalf. They're trying to enter the courtroom, but they're not allowed. They're not being allowed to enter. And they need seating.
So I'll wait on them to come in.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
Well, I didn't call, but let me just finish.
Okay.
Because you said to me,
So Georgia Association of Criminal Defense Lawyers, the whole posse was down there. I don't know how many of them, but they needed seating. And Ashley Merchant is a member. And they represent lawyers in this particular predicament. When they are found in contempt and they have to go to jail, they represent them. And Ashley Merchant is part of this association, and she came into the courtroom to represent Mr. Steele, Attorney Steele, along with some other lawyers, because like I said, it's a whole group of them.
that you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. But they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not. No, we just.
Or they're not in your courtroom.
We just don't have any. We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can. That will fill up our benches at this point in time. That won't violate our security protocols. But that 8H is available, and
8H then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. We'll let Ms. Merchant in. That's fine. Ashley Merchant. Yeah, Ashley Merchant.
Ashley Merchant, yes. Ashley Merchant is present.
All right.
So you guys remember Ashley Merchant. She was part of the Fannie Willis hearing. And she is sharp, folks. She's really sharp. She's the one who did all the probing and digging and investigation and found out all the information about Fannie Willis and Nathan Wade.
Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt. I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no superseded bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is because of the way this information was disclosed, it is troubling to the court, and it's very, since it was a ex-parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
And Judge, can you come up to the microphone? Sorry.
Please. Microphone, it'll pick up, madam.
Thank you so much. Just for our action. Which one?
It'll turn green. Turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
well, and okay. Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding, and so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399, and it says that is one of the cases. Also, two other cases: Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215 Georgia App 372.
Okay.
According to Washington Post, on Monday, Fulton County Superior Court Judge Ural Glanville abruptly halted the trial indefinitely until another judge reviews motions from Young Thug and others who have accused the judge of misconduct and want him recused from the case.
I distinguish your two cases that you've given me thus far.
So those were only the initial two. I had a couple others.
Okay, go ahead.
As well, yes. So Ramirez versus State, it's 279 Georgia 13, 2005. It also...
You said 279 Georgia what, I'm sorry?
Georgia 13.
Georgia 13?
Mm-hmm. It's a 2005 case.
Right. And
it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
See, but you're all covering under... let me see.
I'm sorry, Judge?
Hold on. Just a second.
So Judge Glanville looked up the precedented cases that Ashley Merchant mentioned.
Contempt is direct. The trial court has the power after conforming the contemptor to opportunity to speak in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So...
and Judge, there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that...
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarty, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay.
Well, you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I say that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So, first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So, you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
So Ashley Merchant took Judge Glanville back to school. He had to be looking stuff up. Well, that was 3 weeks ago. They went further with this motion, filed it in the appellate court. Well, they're still waiting for a decision. But in the meantime, Judge Glanville shut the case down until further notice. Let's continue.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact or has filed, and I will note this as part for the record. In this case, conduct didn't rise to a level that necessary.
So on Monday, Judge Glanville made a decision to not continue with the trial until a decision is made by the appellate court. So the jurors are waiting, judge is waiting, attorneys are waiting, and the defendants are waiting. And so there's speculation now that this trial is a done deal because when jurors are out, Their instruction is not to read the papers and go on the news and listen to what people have to say and discuss the case. But now they're going to be sitting at home waiting, and guess what? They are going to be discussing the case, and they are going to be getting external influence their decision. The jurors that are on this case, it took, I believe, 10 months for them to get those jurors, and because of the case lasting so long and it's worldwide, a lot of people who didn't know about YSL now knows about YSL and the case and the rapper. So a lot of people have their own opinions. The jurors are going to hear those opinions by the time they get back to the case. If it resumes, they're going to have a different opinion. And so there's speculation from a lot of attorneys that this case is done. They may have to move for a dismissal, but we will see. So 11 Live News gives us an update as to their opinion on the YSL case.
Well, tonight the future of the YSL RICO trial involving rapper Young Thug is in, well, limbo after a motion to take this case away from Fulton County. And 11 Live's Grace King is explaining why the defendants want a judge outside of the county to weigh in.
What I want to know is why wasn't I there? Why, sir, I'm going to hold you in contempt.
After weeks of tension, Judge Glanville letting someone else decide whether he should stay on the YSL RICO case or recuse himself after allegations of improper conduct during an ex-parte or private conversation between Glanville, prosecutors, and Lil Woody, a witness who refused to testify on the stand. The meeting did not include defense attorneys.
This is a really serious and scary moment for everybody involved in this case. It could spell the end of the state's effort to pursue justice, or it could lengthen the already longest trial George has ever seen.
Criminal defense attorney Joshua Schiffer, who isn't involved with the case, says the question now is who's qualified to make that decision. Fulton Judge Belinda Edwards immediately recused herself after being assigned the case, and with the new motion, the attorney for Diamante Kendrick is hoping Judge Rachel Krause will do the same.
So Judge Belinda Edwards was assigned the case to hear it, to determine if Judge Glanville should continue on the case or step aside, and she recused herself right away. It's going to be hard pressed to find a judge really to sit on this case and make a determination, because he knows pretty much all of them. They work together, and so it's going to be a difficult find to find a judge who will sit on this case and make a determination. The case may have to move out of the jurisdiction of Fulton County.
It's alleging that due to Judge Glanville's existing relationship with the rest of the bench and his behaviors in this specific trial, there's no way an independent ruling can be issued by anyone in Fulton County.
Legal experts tell me time is of the essence because this case already has a jury attached to it. Judge Krause gave the state until July 8th, this Monday, to respond to those recusal motions. In downtown Atlanta, Grace King, 11 Alive News.
So guys, this case, like I said before, might be dismissed because of the jurors now out. Well, they're supposed to adhere to the judge's instructions. However, they're back home among their families and friends, and I'm sure somebody's going to discuss this case, which will influence their decision making when it comes for them to cast their vote, guilty or innocent.
Young Thug's attorney Brian Steele wins jail time appeal for contempt of court, reports. The judge said he would release a transcript of the meeting, according to the outlets. Last month, the rapper's attorney, Brian Steele, was taken into custody for alleged contempt of court after he refused to disclose to Glanville how he learned of the private meeting between the judge and prosecutors in the case. "You got some information you shouldn't have gotten," Glanville told Steele, per the Atlanta Journal-Constitution. The attorney was ordered to serve a 20-day sentence over 10 weekends, but the Georgia Supreme Court granted an emergency motion for bond, meaning he no longer had to report to jail, according to the Atlanta Journal-Constitution and the Washington Post. Young Thug's lifestyle played in court as Atlanta rapper faces RICO charges. A Fulton County grand jury indicted Young Thug in May 2022. A second indictment in August 2022 accuses Young Thug and 27 other people of conspiring to violate Georgia's Racketeer Influenced and Corrupt Organizations Act, known as RICO. The indictments contain 65 counts of felony charges, 6 of which apply to Young Thug. Young Thug RICO trial halted indefinitely amid Fulton County judge scrutiny. A judge in Fulton County, Georgia, paused a famous rapper's racketeering trial indefinitely on Monday while 3 requests for the judge's recusal from the case are being taken under consideration. Judge Ural Glanville, who sparked controversy with a one-sided, closed-door meeting he had with prosecutors last month, said he would follow court rules and transfer the 3 requests to another judge, who will decide Glanville's fate. In the meantime, Glanville declared the drawn-out and tumultuous trial of Young Thug, a Grammy Award-winning artist, in recess, further prolonging any conclusion to a years-long court matter that has eaten up enormous resources in District Attorney Fani Willis's jurisdiction. Phil Holloway, a conservative Georgia-based attorney, shared a clip on X of the proceedings during which Glanville announced the trial pause. Holloway opined that the judge realized he's been checkmated. Calls for Glanville's recusal began last month, when Young Thug's attorney Brian Steele confronted the judge about the meeting he had with prosecutors and a witness who was set to take the stand and testify against Young Thug. The meeting was considered ex-parte because it included only one party in the case, and Steele alleged that a mistrial was warranted because such meetings are frowned upon in judicial codes if they involve any sort of substantive matter. In a stunning reaction, Glanville did not address the meeting but instead demanded to know how Steele found out about it. Steele refused to divulge his source, leading Glanville to order the lawyer's arrest right in the courtroom for alleged contempt of court.
Involved, and they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this.
So Mr. Copeland is one of the witnesses against Mr. Williams, YSL. And so his attorney Steele, is saying that since the judge spoke with this witness ex parte, it is not the usual. As a matter of fact, it is unlawful. So he has asked for the judge to recuse himself. Let's continue.
Court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
So Judge Glanville wasn't hearing it. He refused to recuse himself, and therefore these attorneys for YSL had no choice than to take it to the Court of Appeal.
Attorney Ashley Merchant later entered the courtroom and came to Steele's defense, saying he was denied due process. Merchant was also at the forefront of the effort to oust Willis from her other high-profile racketeering case, which she brought against former President Donald Trump and 18 others over election interference allegations. A judge granted Steele's release while his fight against his contempt allegation is pending. In addition to holding the defendant's attorney in contempt, Glanville initially denied calls for a mistrial in his recusal, leading to critics raising worries that he was effectively holding the courtroom hostage while Young Thug's trial progressed. Glanville has since responded by releasing the transcript of the ex-parte meeting he had with prosecutors and the witness, and it painted a picture of the judge being instructive with the witness, Kenneth Copeland, also known as Lil Woody. The timing of a separate judge ruling on whether Glanville should be recused for the ex-parte meeting and his subsequent reactions when he was confronted about it remain to be seen. Young Thug and 27 co-defendants were charged more than 2 years ago with a slate of felonies, including racketeer-influenced and corrupt organizations violations, murder, armed robbery, and illegal possession of firearms. Young Thug, whose legal name is Jeffrey Williams, is facing 9 charges, which include the RICO violation, participation in criminal street gang activity, and possession of drugs and weapons. He is alleged to have led the gang Young Slime Life, or YSL. YSL Records is also the name of his record label. The trial, which began last November, has dragged out and been plagued with complications since its outset. Its start was preceded by a difficult 10-month jury selection process. Through various requests to sever cases and reach plea deals, the number of co-defendants has been whittled down to 6, all of whom have pleaded not guilty. Copeland, the witness at the center of the latest controversy, was given an immunity deal to testify about a 2015 murder of Donovan Thomas, who was allegedly a member of a gang that is rivals with YSL. Prosecutors allege Young Thug rented a car that was used in the murder. Things heated up in court Monday during the YSL RICO trial after the Young Thug's attorney, Brian Steele, was taken into custody. Judge Glanville held Steele in contempt of court after he refused to disclose his source of information regarding an ex-parte meeting between the judge, the state, and key witness Kenneth Copeland. Judge Glanville repeatedly threatened Steele with contempt, but Steele persisted, accusing the court of coercion due to the lack of representation for his client at the meeting. "I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you in contempt," Glanville said. Steele replied, "I don't need 5 minutes." Following this heated exchange, the court recessed temporarily. Upon reconvening, Judge Glanville again pressed Steele to reveal his source of information. "Mr. Steele, I'm going to ask you again. I need you to tell me how you got this information. This is so sacrosanct to have a conversation in my chambers parroted to you," Glanville exclaimed. Steele refused again, then motioned for a mistrial, which was denied. He was taken into custody shortly after. Nearly an hour later, Steele was allowed back into the courtroom with a deadline until the end of the day to reveal his source or face custody again. The trial, which began in earnest in November 2023, is already the longest in Georgia's history. It follows the arrest of Young Thug, whose legal name is Jeffrey Williams, on May 9, 2022. Williams, a Grammy-winning artist and influential figure in the Atlanta hip-hop scene, has been behind bars for over 2 years. The charges against him are tied to allegations that YSL, Young Stoner Life, the label he founded, is actually a violent gang known as Young Slime Life. Fulton County District Attorney Fonnie Willis indicted 28 people, including Williams, in a sweeping 88-page document. Prosecutors claim that Williams is not just a member but the leader of the gang.
Remember, bias. I've got to do something extrajudicial, and in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse. I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And then you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are committed to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Will you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you're always talking about how the appellate court...
No, because if I grant the certificate, it stops the case, okay?
I don't agree.
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you're going to appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
And aren't you interested in removing the cloud that's hanging over the case right now, Your Honor?
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that, tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to deny the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please? Mr. Weinstein, I am going to prepare a written order, okay?
Okay, thank you.
All right. Okay. All right.
Young Thug's RICO trial on hold indefinitely after judge's alleged improper meeting. Glanville agreed that the trial will not proceed until another judge decides whether he should recuse himself from the trial over alleged misconduct. The Fulton County judge got into a heated argument with Thug's attorney Brian Steele over the meeting with witness Kenneth Copeland, arguing that it was. Glanville has now agreed to make the transcripts from his meeting with the witness and prosecutors public. Steele recently filed a motion to dismiss Glanville from the trial, claiming he had an unlawful, improper ex-parte meeting with Copeland, who had previously been granted immunity by the prosecution in exchange for his testimony. Steele claims that he and Thug received no notice of the meeting and that it violated the rapper's constitutional and statutory rights, including the right to due process, a fair trial, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. In the motion to dismiss Judge Glanville from the trial, Steele accuses him of being biased towards the prosecution. Steele rode with the judge after he found out about the meeting with Copeland, with Glanville ordering the attorney to reveal who told him about the meet. Steele refused to tell the judge who tipped him off, and in dramatic scenes, had the lawyer arrested for being in contempt of court, all of which was caught on a courtroom livestream. Steele later said he wanted to spend his jail time with his client Young Thug to continue preparing their defense against the RICO charges. Steele managed to avoid jail time after being granted bond, pending the appeal of his contempt charge.
As you leave the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you for watching.